On this edition of Law Weekly, we talk about the recent controversial amendment of the Legal Practitioners' Rules of Professional Conduct by the Attorney General of the Federation, some challenges trailing the issuers of the stamp and seal for lawyers, and what skills the new wigs need to get good jobs and to generally thrive after their call to bar. We have the views of a senior advocate of Nigeria, Tayo Oyetibo. Also showing on the program, the highlights and also the expectations from the training for judges appointed to serve as members of the Edo and Ondo governorship election tribunals. Hello and welcome to the program. I'm Shola Shieli. On Saturday, September 12, the legal community was confronted with the news of a gazette which purportedly emanated from the Attorney General of the Federation and Minister of Justice, Abubakar Malami SAN, on the amendment of the rules of professional conduct for legal practitioners, especially on the requirements of stamp and seal for the lawyers. The news of the Gazette sent ripples across the legal community, with many lawyers wondering where the AGF got the powers to make such amendments. The president of the Nigerian Bar Association, Olumide Akpata, has since reacted and said that the AGF cannot unilaterally amend the rules. He's also said that the NBA is consulting with the AGF on the issue and would give further updates in the coming days. Expectedly, reactions have not stopped trailing the issue, and it's the starting point of my conversation with Senior Advocate of Nigeria, Tayo Oyetibo.
Well, I've read some of the criticisms, and I think some unfair, some saying what it is, how it is. I think the proposed amendment was said to have been made pursuant to Section 12, subsection 4 of the Legal Practitioners Act. If you check the existing provision, the existing rules, those rules were expressed to have been made pursuant to the same section. So if you criticize the proposed amendment, you must go back to criticize the one that is in existence. If what is proposed to be done is not right, then the existing one is also not right. So they are in the same boat. Precisely. Section 12 of Section 4 does not give power to make amendments to the rules. But the existing rules were expressed to have been made pursuant to that provision, and nobody has ever spoken against it. So my view is that what is bad for this one is also bad for the old rules or the existing rules that are being used. There is no power in Section 12, subsection 4 of the Act given to the AGF to amend rules. But as I've said, he merely followed what was in existence.
Now, some lawyers have argued that the stamp and seal ought to be issued by the body of benchers and not the Nigerian Bar Association, and that proceeds from there should go to the Federation account since it came about from a federal subsidiary legislation. Do you agree?
That cannot be so. That cannot be so. If you pay to Federation account, then how do you issue the seals? How do you pay for the cost of issuing the seals? It's the NBA that issues the seals to lawyers. But I do not agree that proceeds of the seal should go to the Federation account. Why should it go to Federation account? It's a professional issue. You pay to the body that is issuing the seal because it is part of the money that you pay that will be used to settle the cost of production of the seal. So it can't go to Federation account. If it goes to Federation account, then how do you produce the seals? The first question is, do we even need the seals? Do we need the stamps? There are better ways of doing things. You pay for the seals, you pay for the stamps, you don't get the stamps delivered to you. And even when they are delivered, before you say Jack Robinson, they have expired. Why do we have to go through that rigorous procedure? If you pay your practicing fees, we can put in place a mechanism whereby when you pay your practicing fees, automatically a number will be generated to you for that year, which you can endorse on all processes and documents that you prepare as a legal practitioner to show that you have paid practicing fees. The idea of this stamp and seal, it has not worked since it was introduced, and it's not likely to work because of the inefficiencies that normally go with things like that.
There's also this argument that the NBA is not a federal statutory institution, that it is just a private association registered under CAMA by some lawyers for their welfare. So its claim to exclusivity is faulty. Is this a sound argument?
You see, it is not correct that the NBA was
registered. These are lawyers that are also saying
yes, of course, they are entitled to their opinion. Everybody is entitled to his opinion, but it is not correct to say that the NBA was registered by some lawyers. NBA came into existence as an organization to protect the interests of lawyers, just as you have it in every other profession globally. But it is correct to say that it is not a federal institution. It is not an agency of the state. It is a professional body registered under the existing law, or deemed to have been registered under the existing law. And it has its trustees, registered trustees. So it is correct to say that it is not an agency of the federal government or of any state. It is also a voluntary association. But because of the history of the NBA, almost automatically, every lawyer that is called to the bar becomes a member of the association. But it's a voluntary association. If you feel that you don't want to belong to the association, nobody can compel you. But you will run into a problem at some point in the course of the practice of the profession. Yes, that's the position.
So the move by some lawyers to form a parallel association, what do you make of that one?
As I said earlier on one occasion, you see, you can't stop people from forming associations. People can form association in exercise of their right to freedom of association. But the question is, how long will it survive the system? All lawyers in Nigeria look up to the Nigerian Bar Association. That is the national body that people look onto as their association. But some people can form their own association. But our own association is Nigerian Bar Association. And that is what every lawyer believes in. But you can't stop people from forming their own association. So you have our own association and their own. That's the National Association, which is the Nigerian Bar Association. But as I said, it's a voluntary association.
Let's move on now from issues affecting the profession to issues affecting the country. And I want to specifically talk about the moves by the National Assembly to again amend the Constitution. Some people say it's a step in the right direction. Others say that it's not necessary, especially because they think that it's self-serving. We've been down this road too many times before. What do you think?
You see, the Nigerian Constitution is and has been held to be an organic document. Organic in the sense that it cannot be static. It must develop with developments in the socio-political environment in which it operates. So if there are provisions in the Constitution which require amendment because of socio-political developments, I think it is necessary to do so. But amendments to Constitution is not an end in itself. You can amend your Constitution every day, every hour, every minute, every second. If the operators of the Constitution do not believe in the provisions of the Constitution, you are not going to get anything. You may also not even have a Constitution. Like you have a Great Britain, they don't have a written Constitution. Yet, they observe all the conventions that have been in place over the years. But in our own case, we have written Constitution, 1979, amended, first alteration, second, then 1999 Constitution, first alteration, second alteration, third alteration, fourth alteration. Yeah, you still have crises anytime you have elections, anytime you have one issue or the other. So, do the operators of the Constitution believe in the provisions of the Constitution? And I have always emphasized it, and I believe that until we have matured politicians, you can amend the Constitution 1,000 times. It's not going to get you anywhere. It's not going to get you anywhere. If you don't believe in the provisions that you are bringing into existence by way of amendment, where has it led you? You still have election petitions on each election that we hold in this country. Series of petitions. And there are countries that do not have written constitutions. Once an election is held, everybody accepts the result and they move on. So which one is better? Almost all the amendments, we have one thing or the other to do with our elections. So that is the problem. Then secondly, we spend so much money on constitutional amendments. So we have to rethink. Because this is where we said that there's no money, but the money goes to unproductive sectors.
At the recently concluded 60th conference of the Nigerian Bar Association, President Muhammadu Buhari made a case for speedy dispensation of justice when he called for reforms that would see criminal cases decided within 12 months and civil cases decided within 15 months. How do you think that we can best achieve this?
I think, with great respect to the president, he should look into funding the judiciary first. You are putting the cart before the horse. If you want the judiciary to complete cases within 1 year, you will go and investigate what is the problem of the judiciary. What are the facilities available to the judiciary? You can't say finish a case in 1 year. And you know the number of cases that the Supreme Court have to contend with in a year. Almost all the largest across the globe. And how many justices do you have in the Supreme Court? What are the facilities available to the Supreme Court justices that you want cases to be completed in 1 year? Go back to the High Court. Go and look at the High Courts. Look at the High Court of Lagos State. How many judges do they have? How many cases do they deal with in a year, or in a month? What are the facilities available to them? Some still write in longhand. Some don't have a judicial assistance. So how do you conclude cases in 1 month or in 1 year? So those are the problems that confront the judiciary. You have to invest in the judiciary if you want the best from the judiciary. You have to engage, you have to recruit the best of lawyers. And the best of lawyers will not go to the bench if there's no attractive the facilities. You don't want to leave the comfort of your office. You have all the facilities you can work with as a private practitioner to go and serve on the bench when the facilities are not there. So those are issues that the government have to look into. It is when you have resolved all of those issues that you can then say, yes, now that we have provided you with all the wherewithal that you require to do what we want, we will now say, let us amend our laws to be able to do this, to be able to do this, to be able to do this. But you cannot start with finished cases in 1 year, and you don't want to know what goes into the hearing of a case, the determination of the case, and the delivery of the judgment. You don't want to be concerned with that. I mean, you are not going to achieve that.
Let's end with something for the new weeks, because I want them to get some benefits from this program. 1,785 of them have just been called to the Nigerian bar. As an employer of labor, what skills would you say that the young lawyer needs to possess in this COVID environment, especially beyond their school certificates?
For a new week that is coming into practice, first, when you leave the law school, you have received training as to how to find the law. It is when you come into real practice that you come in contact with live cases, and then you begin to apply the knowledge that you acquire in the university and at the law school to real life situations. For a new week that is coming into practice, first of all is what have you been equipped with in terms of present day practice? So your writing skill, your understanding of the law, and also your research capability. Those are essentially what any employer of labor will want to look for in a new week that is coming to practice. Now, if you look at the number of lawyers that were produced, this last batch of a call, I think about 1,785 of them. And I think Nigerian Law School now produces about 2 batches of lawyers within an academic session. I think the managers of the economy ought to be looking into how to absorb all these new graduates, new lawyers that are being released into the economy. You can do this by law. You can enact laws to cater for situations that develop around the human resources of your country. Take lawyers, for example. If you are producing 1,800 and something lawyers in 1 year or even more, you need laws to cater for them. We have about 774 local government councils in Nigeria. You can enact a law that requires the minimum number of lawyers that each council must engage. We have police stations across the country. You can enact laws that will make provision for minimum number of lawyers that each police station must have. Because these are sectors of the economy that have contact with members of the public that require the application of the provisions of the law. So you need lawyers in those sectors. But is the government thinking along that line? How to absorb all of these lawyers? Because when you produce 1,800 and something lawyers into the system, and there's no provision for how to absorb them, you are creating problem for the system. Serious problem. So it is the private sector that is now left to take most of these lawyers. And if there's no, and the economy is not doing well, so you must be able to develop your economy using the instrumentality of the law.
Welcome back. In other issues, attention will soon shift to the election tribunals. But before then, following the inauguration of the 85 judges that will be serving on the Edo and Ondo State Governorship Election Tribunals, the Court of Appeal has organized a training to keep the bench abreast of the laws guiding conduct of elections in the country. Let's look at the highlights from that training and some of the expectations from the judges.
Election tribunals are established pursuant to Section 285 of the Constitution and Section 133 of the Electoral Act. Section 1, subsection 3 of the 6th Schedule of the 1999 Constitution empowers the President of the Court of Appeal to appoint judges for the election tribunal. After appointment, the President of the Court of Appeal went a step further to organize training for the judges. Here's what she told the judges at the training session.
You are being called upon once more to go out there and decide where votes should have decided, but human nature will always challenge whatever decision is made until affirmed by some other authority. The INEC, I believe, will do its work, but first, the voters will go out, cast their votes. INEC is expected to do its job properly, and yet dissatisfaction will come out, and people will feel dissatisfied with what has been done, and that is what creates petitions placed before the election tribunals. And that is why we are out there as arbiters to adjudicate between these despairing citizens. Ours is to look dispassionately at the facts placed before us and to decide in accordance with the law what we see and declare what we see as it is, not what ought to be.
Section 133, subsection 3 of the Electoral Act specifically makes it mandatory for election petition tribunals to be constituted not later than 14 days before an election is held. And under Section 258, subsection 6 of the Constitution, the tribunal must deliver its judgment in writing within 180 days from the date a petition is filed. Other judges present at the event stressed the seriousness of the work ahead and the expectations from the judges.
Political parties are like a cult. They are followers. And they are very passionate about their own people. Anything they ask them to do, they will do. Go and burn houses, they will burn. Go and burn cars, they will burn. But the election petition tribunals are put in place to make sure that they don't take laws into their hands. And you notice that immediately after the election, don't worry, we are going to the tribunal instead of carrying the machete, instead of carrying gun, instead of burning houses. They say, we are going to the tribunal. It's you. They are coming to you. It's you they are saying they are coming to. They have hope. They have a belief in you that you are going to set right what they term to be the wrong. And that is why you have been selected. And today we are going to prepare you for that task, for the peace of the nation. So don't take it as a small matter. It's not a small matter, it's a very big matter. You have been carefully selected to come here to take the destiny of this nation in your own hands. You know, when the decisions are made, they come out, they say the court they have spoken. And we have nothing else to do. That is why you are here. In fact, the time between the losing of the announcement of the election to the time you make your pronouncement, tempers have cooled, and they're able to now see through what happened and what did not happen. And then the nation will continue to go forward.
You're going to see plenty cases. I asked a political friend why they file election cases. And he told me something that is quite revealing. He said, if I don't go to court, my political value has gone. I need to go to court so that I can say it is the court that gave the other party victory. That's the only way I remain relevant. So note, in the cases you are going to see, you will see the good, the bad, and the very ugly. But take heart, it's a job that must be done. Somebody has to do it. The lot fell on you this time around. Do it to the best of your ability. You will come out unscarred, and then the next batch will be others taking over.
With the conduct of the Edo elections, attention will now shift to the tribunals to do justice to any petition filed.
And just before we go, a quick look at some other top legal stories in the news.
We begin with the report that the Nigerian Bar Association (NBA) has constituted an observer group for the Edo State governorship elections. A statement from the NBA says its first vice president, John Aikpokpo Martins, will lead the group. Aikpokpo Martins, who appeared on Channels TV's flagship breakfast show, Sunrise Daily, says the monitoring takes into cognizance the build-up to the election till the announcement of results. On whether the law will permit the election observers to submit reports that can be relied upon by the tribunal in the event of dispute, he said that it will not be a bad idea if the Electoral Act can be amended, as the duty placed on the loser to prove that the election was not properly conducted is a tall task. In other news, a total of 1,785 lawyers have been called to the Nigerian bar. In strict observance of COVID-19 protocols, the body of benches on Tuesday held the call to bar ceremony for the new wigs at the Eagle Square, Abuja. Parents, guardians and well-wishers were barred from entering the venue. The Director General of the Nigerian Law School, Professor Isa Hayatu SAN, who spoke at the ceremony, said 1,779 candidates passed the January 2020 bar final examinations, while 6 candidates were from previous bar final examinations. He said 736 of the students failed the final examinations. The president of the bar, Olumide Akpata, also used the opportunity of the call to bar ceremony to pledge his commitment to unify lawyers and restore the association's glory. At the courts, a 3-man panel of the Court of Appeal sitting in Abuja has dismissed the application for joinder filed by a faction of the Advanced Nigeria Democratic Party seeking to join the suit filed by Senator Doye Diri challenging the nullification of his election by a tribunal in Abuja. At the hearing of the application, Chairman of the panel, Justice Stephen Ada, struck out the application on the grounds that the applicants led by James Femowe lacked the locus to institute the action as he was not a party at the election petition tribunal. The court, while awarding a cost of 600,000 naira against the applicant and payable to the 3 respondents, further held that the application is frivolous, vexatious, and a waste of judicial time. And we round off with the report that the Bayelsa State government is seeking an order stopping the federal government from deducting monies due to it in the monthly statutory allocation and paying same to Rivers State. At the Supreme Court sitting in Abuja, the Bayelsa State government is invoking the original jurisdiction of the court to stop it from continuing to lose billions of money. The suit is predicated on a December 2019 judgment of a federal high court which the Rivers State government obtained against the National Boundary Commission on ceding the Soko fields.
And here's where we adjourn till next week. Don't forget that you can watch again this episode of the program and past episodes on our YouTube channel. I'm Shola Shieli. Thank you for watching.